Hello, and welcome to this webinar on responding to a Section 22 visit in lockdown. Before we start, just a little bit of housekeeping. You should have towards the bottom of your screen a Q&A button. You will all be muted, I'm afraid, so you can rant as much as you like and I won't hear you. But if you do have a question that you'd like me to deal with, type it into the Q&A. And if I can, I will deal with it. If I can't, then we'll deal with it after the webinar's finished. Okay. My name is David Winch. I'm a chartered accountant and a director in Bartfields Forensic Accountants. And this webinar is on responding to a Section 22 visit in lockdown. There is actually quite a lot of material for us to get through. We may go over the half hour that we've set ourselves, so let's see if we can make a start. The agenda. We're going to have a look at what Section 22 means, and in order to do that, we have to look first at the predecessor legislation, and then where Section 22 sits within the Proceeds of Crime Act 2002. Then we're going to look at a typical prosecution application, what Section 22 requires, and then talk about discretion and available amount, and Section 22 applications and benefit. And finally, some case law, and then how can we at Bartfields help you? So the typical situation, if we are facing a Section 22 application, is this. The defendant was subject to a confiscation order made under the Proceeds of Crime Act 2002 some time ago. That confiscation order showed a benefit in excess of his available amount at the time. The defendant currently has assets, and the prosecutor has made an application to the court under Section 22 seeking a further payment under the confiscation order. So that's the typical situation we're dealing with if we're facing a Section 22 application. As I'll mention, that's not the only case in which the Crown might make a Section 22 application, but we'll talk about that in a minute. Before we get into the nitty-gritty, we're in the middle of a pandemic. Let's just have a word on the valuation of assets. The valuation is to be market value, and that's prescribed by Section 79 of the Proceeds of Crime Act 2002 of PoCA. There's also some useful case law, the case of Islam in the House of Lords as it then was in 2009. And in that judgment, we find this from Lady Hale. When we are looking at what is available for confiscation by the state, we look at the market in which he, the defendant, can properly be expected to realise the value of property he holds. And it was also said in that case, the market value of goods is the price which a willing seller will accept for them from a willing buyer. Now, of course, if we're having to pay off a confiscation order, we may not exactly be a willing seller. And so we might find that we get a value, realise a value that's less than the market value. Again, that's something we'll talk about a little later. But those are the ground rules for the valuation of assets in confiscation proceedings generally. Okay, I said we'd look at the predecessor legislation, and we're going to look at Section 16 of the Drug Trafficking Act 1994. Now that act was superseded by the Proceeds of Crime Act 2002. But where a confiscation order has been made originally under the Drug Trafficking Act, then it will still be under that Act, and Section 16 actually will still apply. What did Section 16 say? If the High Court is satisfied that the amount that might be realised in the case of the person in question, the amount that might be realised in the case of the person in question is greater than the amount taken into account when making the confiscation order, whether it was greater than was thought when the order was made or has subsequently increased, Then under section 16, what happened was that the High Court gave a certificate to that effect. And then the matter passed over to the Crown Court. The Crown Court, receiving the certificate from the High Court, was then able to substitute a new amount to be recovered in the confiscation order. Now, there were some difficulties with that process. One thing was that it's a two-step process. It involves going to two different courts, which is a bit clumsy. But also a question arose, what about an asset that was first acquired by the defendant after the confiscation order was made? What's called an after-acquired asset. Is that to be taken into account in section 16, or is it not? Well, the matter wasn't finally resolved until the case of PoCA in 2012 in the Supreme Court. And that resolved the issue by saying that, yes, after acquired assets were indeed to be taken into account under the Drug Trafficking Act. The Supreme Court also said this, there is a striking symmetry, as they called it, a striking symmetry between the sections of the Drug Trafficking Act dealing with increases in realisable amount and those dealing with inadequacy of realisable amount. And I would suggest to you that there is a same striking similarity under PoCA between section 23, which we discussed in a previous webinar, which deals with inadequacy of inadequacy of available amount, as it's called under PoCA, and section 22, which deals with increases in available amount. And that symmetry is useful in understanding what these sections mean. But in PoCA, although it was a case under the Drug Trafficking Act, there was mention of section 22 and section 23 of PoCA. It was said, section 23 and section 22 of PoCA solve the problem of section 16 of the Drug Trafficking Act 1994 by making it clear in express terms that the available amount is to be reassessed at the time of the new calculation. So what I'm saying here is that the Supreme Court is saying, actually under PoCA, the test is slightly different. Not only is the procedure different in that we don't go to the High Court and the Crown Court, but the test is different as well. And if we look at the explanatory notes to section 22 in PoCA, the explanatory note says, this is an example of a function exercised by the Crown Court under the new Act, under PoCA, that had previously been exercised by the High Court. So what they're saying is that the granting of the certificate by the High Court, the deciding of whether this was a case in which there could be a variation to the existing confiscation order, that was done by the High Court previously. It's now done by the Crown Court. And in fact, it's done by the Crown Court at the same hearing at which a decision is made on the variation. So although there's now only one hearing, there is still a two-stage process within that hearing, and we mustn't forget that. Let's have a look at where section 22 sits within the Proceeds of Crime Act. And it sits amongst a group of sections dealing with reconsideration of a confiscation order. Sections 19 to 21 deal with reconsideration of benefit. And they deal with the situation in which there is now new evidence which was not available to the prosecutor at the time the court previously made its decision about the confiscation. So there's new evidence available, and that evidence relates to events or conduct which occurred before the original decision was made. So in circumstances where the prosecutor finds out after the confiscation order has been made that there was an additional source of benefit that he should have taken into account, but he was not able to because he didn't have the information, and the inference is he should have had that information and it should have been before the court, then In those circumstances, the prosecutor can go back to the court and ask for the benefit figure to be reconsidered because of events or conduct that occurred before the order was made. The court, on reconsideration, it makes a new order or it remakes the existing order under Section 6. Section 6, of course, is the main section within PoCA which deals with the making of a confiscation order. So we're using here the machinery of Section 6 again to remake the order. Section 6 requires some little modifications so that we are dealing with events or conduct before the original decision was made, but that's the machinery we're using under sections 19 to 21. And so sections 7, 8, 9, 10 and 16 to 18 apply as well, with some modifications. And you'll see those modifications in section 26. But basically, section 7, as you remember, is the section that deals with the recoverable amount and which places a burden on the defendant to satisfy the court if his available amount is less than his benefit. Section 8 deals with what conduct we bring in and deals with confiscation proceedings where the same defendant is subject to a second set of confiscation proceedings under criminal lifestyle provisions, for example. Section 9 deals with available amount. We're going to talk a lot about section 9. Section 10, the criminal lifestyle provisions. Sections 16 to 18, you're very familiar with, deal with the information which the defendant has to supply to the court, deal with the information which the prosecutor has to supply to the court when the court is considering making a confiscation order. So all of those sections apply with some modifications under sections 19 to 21, where we are reconsidering benefit. There are also, within the same group of sections in PoCA, sections dealing with the reduction of available amount. And of course, we've discussed section 23 at the previous webinar. These sections 23 and 24 deal with the reconsideration of available amount, not benefit, available amount. And here we're looking at new evidence relating to events that have occurred since the order was made. So sections 19 to 21, we're looking before the order was made. Sections 23 and 24, we're looking to events that have occurred since the order was made. Section 9 applies with modifications. And if a trigger condition is satisfied, and trigger conditions are different in section 23 and 24, but if a trigger condition is satisfied, the court on reconsideration has discretion to vary the amount required to be paid under the existing order, or in the case of section 24, to discharge the order. So here we are not making a new order or remaking an order, we are varying an existing order in the light of events that have occurred since the order was made. And in this case, we're not using the machinery of section 6. So sections 6, 7, 8, and 10 do not apply. Section 9, of course, does, because that deals with the calculation of available amount, and that's what we're looking at. And equally, under sections 23 and 24, sections 16 to 18, about statements to be made to the court by the defendant and the prosecutor, they don't apply either in those cases. Section 22. Section 22 kind of sits in the middle. It's involved with reconsideration of available amount, although, as we will see later on, benefit is relevant as well. But we're dealing principally with reconsideration of available amount under section 22. And we're looking at new evidence which is relating to events before or since the order was made. Now that's important. So there can be a section 22 application based on events before the order was made. Let's suppose that an order was made 2 or 3 months ago, and the prosecutor now discovers that actually the defendant has a further property which wasn't taken into account in arriving at his available amount and should have been. What does he do? He makes an application to the court under section 22 to have the available amount reconsidered. Now, you might think that it would have been more sensible for the legislators to have two separate sections, one dealing with new evidence relating to events before the order was made, and a different one dealing with events since the order was made. Well, it might have been more sensible, but they didn't do it. Section 9 applies with modifications. And here, if a trigger condition is satisfied, and we'll look at what the trigger condition is later on, if a trigger condition is satisfied, the court on reconsideration has discretion to vary the amount required to be paid under the existing order. So again, similar to section 23, we're not making a new order, we are varying an existing order. Section 23, of course, we're looking at reducing the amount required to be paid under the order. Section 22, we're looking at increasing the amount required to be paid by varying the order. And here, we're not using the mechanism of section 6. Section 7 doesn't apply because that applies to recoverable amount for the purposes of section 6. Section 8, referring to conduct and benefit, doesn't apply. The criminal lifestyle assumptions of section 10 are not going to be relevant, they don't apply. And also sections 16 to 18 do not apply to section 22 applications. So there isn't an obligation for the defendant to file information, there isn't an obligation for the prosecutor to file a section 16 statement and the defendant to reply. In fact, if you look at the criminal procedure rules in relation to section 22, they say that the prosecutor may accompany the application with a witness statement. And of course, in practice, the court is going to want a lot of information, which the prosecutor is going to want to supply. So yes, the prosecutor is going to make a witness statement. And it has some similarities with section 16 statement. So let's think about that prosecution application. What's it going to look like? Well, typically, what has happened is that the prosecutor has identified new assets or increased asset values. And he sets that out in a witness statement, and he also summarizes in that witness statement the original confiscation order, says something perhaps about the original confiscation proceedings, and also any later variations. For example, if there's been a variation under section 23 of the available amount, or a variation under section 21 of the benefit, he's going to mention that. He's going to also provide information on any current restraint order. And when I said that there isn't an obligation for the defendant to supply information under section 18, well, there isn't. But if there is a restraint order, then as part of that restraint order, there may be an obligation on the defendant to supply information, which is going to be used in the section 22 proceedings. So it may be that the defendant is put under an obligation in that way, rather than under section 18 or section 17. And the prosecutor's application will specify a new figure for what might be described as the available amount, or an aggregate of the defendant's previous available amount and his new available amount, which we will look at in some detail in a minute. Also, the prosecutor typically provides a table of default sentences. Okay, so that's what the typical prosecution application is going to look like. But what does that typical prosecution application fail to do, or it may fail to do? Well, I'm going to suggest to you that it fails to do a lot of things that it ought to do. It may fail to correctly perform the new calculation required under subsection 3. It may fail to establish the relevant amount under subsection 8 and to address changes in the value of money under subsection 7. It may fail to consider whether the trigger condition in subsection 4 has actually been satisfied. You remember we talked about the two-stage process, that in the old legislation, stage one was in the High Court. Well, we still have a two-stage process. It may fail to consider stage one of that process at all and go straight into stage two. It may fail to review the original benefit in relation to what may be just. And it very likely will fail to consider the implications of section 39 with regard to default sentence. And we're going to say more about all these things in a minute. Perhaps most importantly, the prosecutor's application may confuse or conflate the result of the new calculation under subsection 3, which is the defendant's available amount today, with the proposed revised amount required to be paid under the confiscation order. And that's going to be the aggregate of the amount previously required to be paid and any additional amount which the court may order the defendant to pay as a result of this application by the prosecution. But note that aggregate really should not be described as the defendant's available amount. It's not the defendant's available amount today. It's not the defendant's available amount previously. Let's have a look at what section 22 actually says in a little bit of detail. And I'm sorry, we do have to look at this in a little bit of detail. So section 22, subsection 3, what does that say? In a case where this section applies, the court must make the new calculation. And this is a new calculation of the defendant's available amount. And in doing so, it must apply section 9 as if references to the time the confiscation order was made were to the time of the new calculation. So how does that work? Well, let's have a look at what section 9 actually says. Subsection 1 of section 9 says this: for the purposes of deciding the recoverable amount, the available amount is the aggregate of A, the total of the values at the time the confiscation order is made of all the free property then held by the defendant, minus the total amount payable in pursuance of obligations which then have priority. And obligations which then have priority are things like secured liabilities, mortgages on property, for example. And we add to that the total of the values at that time of all tainted gifts. So the total of the values at the time the confiscation order is made, well, we're now going to say, no, the total of the values at the time of the new calculation. So the total of the values at the time the new calculation is made of all the free property then held by the defendant, minus the total amount payable in pursuance of obligations which then have priority, and the total of the values at that time of all tainted gifts. So that is the defendant's available amount today. Now, beware of a little catch here with regard to tainted gifts. Suppose the defendant was subject to a confiscation order made, let's say in 2010. And let's say that he had a criminal lifestyle and the criminal lifestyle assumptions went back to 2003. So the relevant day was in 2003. When we're thinking about tainted gifts, we're thinking about tainted gifts made after the relevant day. So we may have to look back at all the gifts that the defendant has made since the relevant day, in this case 2003. We may be looking back over a period of 16, 17 years here to pick up tainted gifts and to bring them into account in his available amount today. So there is a danger there with regard to tainted gifts. And obviously, if he had made tainted gifts which were taken into account in his available amount in the confiscation order, then those tainted gifts are going to be taken into account in his available amount today. But other than that, we're looking at his assets and liabilities today. So if there are assets which he did have at the time of the confiscation order, but which he no longer has, for example, he might have realized them to pay off the original order, then we don't take those into account in this new calculation under subsection 3. Subsection 4. Subsection 4 says this: if the amount found under the new calculation, so that's his available amount today, exceeds the relevant amount, the court may vary the order by substituting for the amount required to be paid such amount as it believes is just, but does not exceed the amount found as the defendant's benefit from the conduct concerned. So if the amount found under the new calculation exceeds the relevant amount, that's the test under subsection 4. What's the relevant amount? Well, the relevant amount is defined by subsection 8. The relevant amount is the amount found as the available amount for the purposes of the confiscation order, if this section is not applied previously. And that will be the case most of the time. So what we're saying is, does his available amount today exceed the available amount shown in the confiscation order? But if there's been a previous revision under section 22, then instead of the available amount under the original confiscation order, we look at the amount last found as the available amount in pursuance of this section. Now, I can hear you thinking, well, what if there's been an amendment to the available amount under section 23? What if the available amount in the confiscation order was subsequently reduced under section 23? Surely we take that into account. Well, there's no mention of that in section 22. So that is a difficulty for us in understanding exactly what section 22 is going to mean in those circumstances. What the statute actually says is the relevant amount is the amount found as the available amount for the purposes of the confiscation order. Now, does that mean, when it says for the purposes of the confiscation order, does it mean when the confiscation order was made, or does it mean as amended? And if it means as amended, well, what's the point of subparagraph B, which talks about an amendment? It's not entirely clear that. Let's not forget subsection 7. Subsection 7 says this: in deciding whether under this section, whether one amount exceeds another, the court must take account of any change in the value of money. In deciding whether one amount exceeds another, the court must take account of any change in the value of money. So let's boil that all down and let's look at what section 22 actually requires us to do. Well, the first thing I suggest that we do is identify the relevant amount under subsection 8, which is the previous available amount. Then we uplift that relevant amount for changes in the value of money since the date it was determined, because we're going to compare that figure with another. We're going to ask ourselves whether this figure exceeds another figure, and so subsection 7 kicks in and requires us to take account of changes in the value of money. And then the court must make a calculation of the defendant's available amount today under subsection 3, applying the rules of section 9 to the situation today. Notice that the burden here is not on the defendant to say what his available amount is. The court must make the calculation, and in doing so, no doubt it's going to take into account what the prosecutor has said in his witness statement and any representations it's received from the defendant and his legal advisors. And then the court makes a calculation of the defendant's available amount today, applying the rules of section 9. And it's going to compare this to the uplifted relevant amount. So the question is, which is higher? Which is the bigger number, the defendant's available amount today or the uplifted relevant amount? If the defendant's available amount today does not exceed the uplifted relevant amount, then I'm going to say to you, the court has no opportunity to vary the confiscation order under section 22. Now, I don't know any prosecutor who would agree with me on that, I have to say. But that is what the Section 22 says. So if the available amount today does not exceed the uplifted relevant amount, then the condition of subsection 4 is not met, and the court, I'm saying, will not be in a position to vary the order. If, however, it does exceed, then the court may vary the confiscation order by substituting a new amount required to be paid. The new amount required to be paid must not exceed the defendant's benefit, but again, uplifted for changes in the value of money since the benefit was determined. Again, subsection 7 kicks in because we are asking ourselves whether one figure exceeds another. So let's think of, let's call him Jim. Jim has a benefit of £500,000 and a confiscation order made a few years ago. At that time, he had an available amount of £100,000 and he was ordered to pay £100,000. So there is £400,000 of benefit, if you like, which Jim has not been ordered to pay. Jim now has assets, and the prosecutor goes back to court and makes an application under Section 22. What the prosecutor has to do is to satisfy the court that Jim's available amount today exceeds his available amount at the time the order was made. So his available amount today has got to exceed £100,000, or to be more accurate, it's got to exceed £100,000 uplifted for changes in the value of money since that available amount was determined. If it does, then the court can vary the confiscation order by amending the amount required to be paid. And the result of that is going to be Jim's going to have to pay some more money. If, on the other hand, Jim's only asset and his available amount today is, let's say, £50,000 in a bank account, then based on what I've said here, the court is not going to be able to vary the confiscation order under Section 22. As I've said, I don't know any prosecutor who would actually agree with me on that, but that's what Section 22 says. So, the defendant's benefit, we've talked about the defendant's benefit. What is the defendant's benefit? Well, the defendant's benefit under Section 22(9) is either the benefit per the original confiscation order, which is quite straightforward, or if there's been a previous variation to the benefit figure under Section 21, the amount found as the benefit at the time of the most recent variation. So the benefit side of things isn't too difficult in that respect. Section 22(4 then, Section 22 requires that the court vary the confiscation order by substituting a new amount required to be paid. And it should substitute such amount as it believes is just. And you'll see similar wording in Section 23. So what this means is that the court has a discretion about varying the confiscation order. In reaching its decision as to what it believes is just, the court must have regard in particular to the matters listed in subsection 5, and these are things like fines, but subject to subsection 6. And the default sentence. Well, where an order is varied under Section 22, and the effect of the variation is to vary the maximum period applicable in relation to the order under Section 139 of the Sentencing Act, then the court may amend the term of imprisonment or detention fixed in respect of the confiscation order under subsection 2 of Section 139. And that's set out in Section 39 of PoCA. But you might be thinking, hang on, this is a reference to the table of default sentences which were used prior to June 2015 for confiscation purposes. Surely that was amended in June 2015, and we now have a new set of default sentences. Well, when that amendment was done, the amendment was made to Section 35. And section 35 deals with the default sentence when a confiscation order is made. But section 39 deals with the default sentence when a confiscation order is varied. And section 39 was not amended, and it still refers to the old table in section 139 of the Sentencing Act. So there's a bit of an issue there as to, if we're varying the default sentence, which table should we be using? Let's have a look at some case law. There's the case of Mr. Cole in 2018. Now, Mr. Cole had an unfortunate habit of getting convicted of serious offences more than once. And the result was that he was subject to a confiscation order, which was made, I think, in 2009, on the basis that he had a criminal lifestyle. This was a confiscation order made under PoCA. And then he came to the attention of the police again, and he was in fact convicted again and made subject to a second criminal lifestyle confiscation order. And the Crown Court was dealing with both of these confiscation orders at the same time, because there was an application by the Crown under section 22. Now, you may think, well, surely somebody's messed up here, because doesn't section 8 apply here, so that the new confiscation order subsumes the old confiscation order? Well, it seems nobody mentioned section 8 to the Crown Court, and what they did was they looked at a section 22 application on the old confiscation order, and at the same time looked at making a new confiscation order in relation to the more recent conviction. In relation to the section 22 on the old order, the court looked at the requirements of section 22, and as the Court of Appeal notes, the questions that then arose under section 22(4)(a) were, number one, whether the new calculation of the available amount exceeded the previous calculation of the available amount, which it did in Mr. Cole's case. What Mr. Cole had done, he rather messed up as well, in that he had, at the time of the original confiscation order, he had a very expensive watch worth a couple of £1,000, and he also had an interest in a couple of residential properties. The interests in the properties were valued, the watch was valued, and the total came to be his available amount at the time. His benefit was much, much higher. It was a drugs case. And the court made an order in the amount of his available amount at that time. So the value of the watch plus his interest in the two properties. The thinking presumably was that he would sell his interest in those two properties to pay off the confiscation order. Well, he didn't. It seems that his mother paid off the confiscation order for him, and he retained his interests in the two properties, which then appreciated in value. Now, I don't know who was advising the mother, but she didn't make a loan to him secured on the properties. She didn't buy the properties off him. She simply left him as owner of those properties, which increased in value. And what then happened was that when he came to the attention of the police again, they looked at his available amount now, the same two properties, but increased in value. He no longer had the watch, that had gone, so forget the watch. The court looked at the current today's value of the interest in the properties, and it'd be no surprise to find that it was greater than the available amount that he had back in 2009. And so it did the new calculation, checked whether the available amount exceeded the previous calculation, exactly what I've been talking about, and it found that it did. And then it went on to vary the first confiscation order under section 22. Let's look at the case of PADA. This is a useful case in setting out the limits, or perhaps lack of limits, on the discretion of the court under section 22. And in PADA we find this. It is entirely appropriate for a court to consider such matters as the amount outstanding, the additional amount which might now be available for further payment, the length of time since the original confiscation order was made, the impact on the defendant of any further payment contemplated, and indeed any other consideration which might properly be thought to affect the justice of the case. So that's the discretion that the judge has under section 22 to look at the justice of the case when deciding whether to vary the order. Take the case of Mundy. Now, there's a useful reminder in Mundy about what is meant by just. The word just means just in all the circumstances, bearing in mind that the purpose of such orders, confiscation orders, is the advancement of the public interest in confiscating the proceeds of crime. So we're not talking only about what's just for the defendant. We're also talking about what is just for the Crown, what is just for the public interest in confiscating the proceeds of crime. Just is not a one-way street. So what happened in Mr. Mundy's case? Well, in Mr. Mundy's case, the sums involved actually were fairly modest. And I do find sometimes talking to judges that they will say, we really don't want to see a section 22 application for somebody who's got a bit of a second-hand van and a few quid. You know, if you're going to do a section 22 application and get the court involved, then it should be an exercise worth doing. In Mundy's case, the sums involved were modest, and the the Court of Appeal reminded itself that judges are entitled to summarily dismiss applications that they regard as being substantially without merit. And in fact, what had happened in the Crown Court in Mr. Mundy's case was that the judge had done exactly that. He'd almost poo-pooed the prosecution application and had decided not to vary the order. But he hadn't given much explanation as to why that was. However, the Court of Appeal looked at it in some more detail and said, we have concluded that it was open to the judge on the material before him to decline to vary the order. And so it upheld the judge's decision in the Crown Court not to make a variation, even though the criteria for making a variation had been satisfied. There was additional assets, but the judge used his discretion to say, no, on this occasion, I am not going to vary this order for reasons which he didn't give in too much detail. But the Court of Appeal upheld that. It's perfectly proper for a Section 22 application to be turned down in the Crown Court at the discretion of the judge. Let's just mention change of law in relation to benefit. Again, we're looking at the case of Cole. One of the things that Mr. Cole had been convicted of, as well as possession of drugs, was in relation to mortgage fraud. And he'd been convicted of this, I think it was in 2009. Certainly it was before the Supreme Court decided the case of Weyer, which we all know and love. And the judge at the Crown Court was asked to limit his variation under Section 22 in relation to the benefit that would have been calculated if Weyer had been decided before Mr. Cole's confiscation order was made, rather than some years after. And the judge in the Crown Court said, no, I don't actually see any injustice in leaving the benefit figure where it is, even though it isn't, if you like, Weyer compliant. Well, the Court of Appeal wasn't accepting that. They said this: once it is accepted that the benefit figure in this type of case falls to be calculated in accordance with the decision in Weyer, the court should not have proceeded under section 22 of PoCA as if where had not been decided. So the judge should have scaled down his view as to the benefit to take account of the decision in where and used that to arrive at a just variation of the amount required to be paid under section 22. What about other change of law? Well, we've mentioned where, and one of the things that Weyer said was that the amount required to be paid should not be disproportionate. But we already know under section 22, the order is required to be just. And it seems to me that an order which is just is not going to be one which is disproportionate in any event, or it should not be. Case of Ahmad, Supreme Court case. Again, I suspect that you will be familiar with this. Where a finding of joint obtaining is made, the confiscation order should provide that it is not to be enforced to the extent that a sum has been recovered by way of satisfaction of another confiscation order on another defendant, made in relation to the same joint benefit. So what that means is that if some of the benefit in the original confiscation order that we're looking at under section 22 was jointly obtained, and it may not at the time have been identified as jointly obtained, because if it was made some years ago, that wasn't a key consideration. But if some of that benefit is jointly obtained, then you are going to want to make inquiries into whether that jointly obtained benefit has already been enforced and recovered from a co-defendant or another defendant. And if it has, it shouldn't be enforced and recovered from your client. So we do get into quite a lot of these potentially difficult areas under section 22. What further issues might there be? Well, time to pay. We talked about time to pay in a previous webinar under section 11. And you might remember under section 11, we have 3 months from the date of the order being made, typically. Step 1 is, if you like, it's payable immediately. Step 2 is 3 months to pay. Step 3 is an additional 3 months to pay under section 11. But those timetables relate to the date when the order is made. And we're not making an order here. The order was made years ago. So how does section 11 apply? And if we don't know how section 11 applies, how do we work out interest under section 12? Because section 12 starts to run from the due date. Well, in practice, what courts do is that they apply section 11 as if it also referred to the date the order was varied. And the default sentence, we've already mentioned the issue about the 2 different tables. But what about reduction for part payment? If we take George, who's had a confiscation order made against him years ago for £100,000, he now has a further £200,000 of assets. So the amount required to be paid is varied by the court, let's say, to £300,000, of which he's paid 100 and he's now got to pay a further 200. So do we set the default sentence in relation to a figure of £300,000 or £200,000? It seems to me that the sensible way forward is to set the default sentence based on £300,000, but recognise that £100,000 has already been paid, and therefore that's going to, if you like, knock a third off the default sentence if he doesn't pay anything further. What about applications under section 23? We talked right at the beginning about valuations, And at present, the open market value between a willing buyer and a willing seller might be depressed anyway because of the pandemic. And if the defendant has got to put money forward within, let's say, 3 months, he might indeed need for a quick sale to sell at less than market value. If there's been a Section 22 variation of available amount, is it permissible to go back to court and ask for a Section 23 variation of the Section 22 figure? Well, yes, it is. Yes, it is. So you may well find yourself, after a Section 22 application has been made, after a confiscation order has been varied under Section 22, going back to court under Section 23 and making an application for that available amount to be reduced. Okay, how can we help? Well, Bartfields Forensic Accountants remains fully staffed. We're undertaking legal aid and privately funded criminal work and civil work. And fortunately, it is relatively easy for us to conduct the bulk of our work remotely using our up-to-date and secure IT facilities. We remain readily contactable by phone and email and online. And our website is full of useful information, accessible 24/7. And in fact, you can find more on this topic and other topics on our website at bartfieldsforensic.co.uk. And this and previous webinars can be found in the seminars section of the website. We will email to you a free recording of this webinar so that you can re-listen if you want to deal with anything that you're not quite sure of first time round. And I am now going to answer your questions. There is a question about the effect of inflation. And this is something that is typically not picked up by a prosecutor. But it does mean that we use the CPIH index to uplift values of historic amounts, so that what we're saying, if you like, is that if the defendant's benefit was £500,000 in 2009, then the maximum amount which can be ordered to be paid under the confiscation order is going to be £500,000 plus inflation, because that's his benefit adjusted for changes in the value of money. So that might be £550,000. So although the amount in pounds is higher, the number is higher, in effect, the philosophy behind this is that the value is the same. What we're saying, in effect, is that a pound today doesn't have as much value as a pound in 2009. And so if we want to create the same value of £500,000 in 2009, then today what we would need is £550,000 or whatever the figure is that the index works out. We're not talking here about interest on money, we're talking about the measurement of value using, if you like, an elastic ruler in terms of the pound shrinking in value over time. Okay, I hope that helps with that one a little bit. If you've got more questions, by all means, email me and I will email you back. Okay, there is just one other question here, which I'll try and deal with quickly. The question is this: if a defendant has defrauded the taxman of, say, £500,000 and purchased properties with it, does the available amount of, say, 1 million, or would you deduct the money used to buy the property as it would amount to double counting the initial money defrauded? Okay, let's be clear. What are we looking at here? Are we talking benefit or are we talking available amount? Because if the defendant has evaded tax of £500,000, let's say, then his benefit is going to be £500,000. We may need to uplift that for the changes in the value of money since he evaded it. We may be in a situation where he has a criminal lifestyle if he's been involved in tax evasion over a period of, let's say, more than 6 months. Or he has multiple occasions of tax fraud dealt with in multiple counts. And he's used it, he's bought a property which is now worth £1 million. The court is going to say that that £1 million represents, as it were, the fruit of the poisoned tree, the fruit of his evasion. There's a case, I think the name is Malden, and I'll come back to you in writing on that, if I may, where an individual benefited from a fraud and used the benefit to invest in properties which shot up in value. And the result was that the newly valued properties were said to be the proceeds of crime, the amount of the benefit. And of course, in terms of available amount, his available amount is what he has now, what it's worth now. So you're not going to be double counting there. At least I hope you're not going to be double counting. We certainly are not going to let the Crown get away with double counting of the benefit or the available amount in those circumstances. Okay. By all means, contact us by email or online. The contact details are there. In a couple of weeks' time, I'm going to be looking at criminal lifestyle in confiscation, which is another topic which causes a certain amount of confusion. So we will look at criminal lifestyle. What is a criminal lifestyle? What does it mean? What are the implications of criminal lifestyle? That will be on the 3rd of June, Wednesday the 3rd of June at 2:30. Thank you very much for listening. I hope to see you in a fortnight. Thank you. Goodbye.